Hello, everyone. Good evening. Good evening. Good evening. How are you all doing? All right. We are here on a Thursday, and I'm here again to give you some updates on immigration news. There's so much going on, guys. It's so hard to keep up with, but I'm going to try to give you some information, and then I'm going to take your questions because I know you guys have a lot of questions, okay? So if you're joining my live for the first time, please remember to, uh, you know, put your name on the comment, say hello. And even if it's not your first time, just say hello, okay? Hey, Hearts, good evening. Nice to see you. So I hope you guys are doing great. It's Thursday, and I wanted to go over some of the news that we have. And for those who do not know me, my name is Ifeoma Odunlami. I'm an immigration attorney at the Odunlami Law Firm. Our office is located in New Jersey. However, we service clients in all 50 states and even abroad. If you have an immigration matter, you want to bring your family members over, you want to file for your spouse, you are a victim of abuse, either as a spouse, a parent, or a child, we can assist you. If you've been a victim of labor trafficking, sex trafficking, we definitely can assist you. If you've been a victim of a crime, those are all pathways to getting a green card in the United States. So our mission and purpose is to help our fellow immigrants get legal status without fear of deportation and without fear of family separation. All right, so that's what we're gonna chat about today. Ladipo Debo, thank you for joining me. Thank you, guys. So I kind of looked through the news to just get some, important details that you might want to, that would be of concern to you guys, something you should know, or something your family members need to know. And then, of course, when we're done, please feel free to ask questions because immigration law is still going on. We're still winning cases. We're still getting green cards for people. We're still getting, people naturalized. So even though the news seems like there's just so much going against immigrants and the immigrant population, I want you guys to know that the lawyers who are still fighting are out there. The justice system is still, upholding the American values, regardless of what's going on with this administration. So I want you to have some comfort in that, okay? So I want to talk about certain things and clear up some misconceptions about some of the things that are out in the news. So let's start with registration, alien registration. So the requirement for non-citizens to register themselves, non-citizens in the United States to register themselves went to effect April 11th. And you're supposed to register using the register online on the USCIS website using the G325R form. And the question which everybody has is, do I need to register? And the truth of the matter is the government hasn't given us a lot of guidance on it, but we've been able to interpret basically certain things based on some information that they have and other information that we've seen in based on, correspondence from there. So we are basically, what we've told you in the past is if you've had any contact with the with immigration, you've got applied for a visa, you've gotten biometrics, you have an I-94, you typically would have been registered. So what I'm going to say is if you're in any doubt, it might be a good idea to talk to an attorney. We're hearing that people who have filed for T and U visas and went ahead to register have been sent correspondence from USCIS telling them that they're already registered. And these people filed an application, got biometrics. So that clearly means that we're, extrapolating that to other applications where you file, you have a biometrics, that means you've registered. So that is for those who want to register. But I want to remind you guys that this registration is an enforcement tool. It does not confer any immigration benefits, none. The administration wants you to register so that they can find you and they can deport you if they are able to do so. That's what that's about. So I want to talk about what are the risks of registering and what are the risks of not registering. So the risks of registering are, number one, if you have no pathway and you're undocumented, the risks include detention, deportation, and criminal liability. Yes, they can charge you with failure to register. And for those who don't register and they have applications, USCIS could use the fact that you did not register to deny an application where they have the discretion to do so or not to do so. So those are the risks. And then for those who register, like I said before, it's an enforcement tool. So if you have any questions about whether or not you're registered, whether or not you should register, you really should have a consultation with an attorney so that they can discuss that with you. So now let's talk about this self-deportation, because I heard that, I read about this, that the Trump administration was incentivizing people to self-deport by offering to pay their flight out of the United States and to give them $1,000 when they got back to their country. You're supposed to use the CBP Home app, register, put your information there. You're supposed to use it to let them know that you have left, and they're supposed to give you $1,000 upon that information. I'm going to tell you though that nobody I know, no attorney I know, as a matter of fact, knows anybody who has been given this information, given this money, or any of this, incentives have actually been given to them. Nobody knows anybody. So if you know somebody who has actually received this incentive, I'll be happy to know, because, right now it sounds like just something the administration is saying, but we don't know anybody who has actually received this incentive. So, but I want to also let people know that this incentive does not apply to everybody. It only applies to people who have categorical categorical parolees. Those are people who their legal presence has expired or will soon expire, like such people such as those people who got their parole through the Biden administration. It's also applicable to people who have had some kind of contact with CBP at a port of entry. So that's something you should know. Now, I also want to address the fact that self-deportation is a myth. You cannot self-deport unless you have an order of a prior deportation already. Just leaving is not a deportation. So there has to be a prior deportation order before you leaving is a deportation. So I want to also be clear that there are consequences to self-deportation, which the administration is not discussing. They're making it seem like if you leave now, you preserve your right to come back. And if you don't leave, you have inadmissibility bars of 3 years or 10 years. And that is not true. You would have those inadmissibility bars regardless whether you leave on your own or whether you leave through CBP Home. You're still going to have those inadmissibility bars. And what that means is that if you're here longer than a year, you cannot come back to United States for 3 years. And if you're here if you're here between 6 months and before a year, you have an inadmissibility bar of 3 years, which means you cannot return within 3 years, subject to waivers and all that. And if you're here longer than a year, you can't come back for 10 years. But the truth of the matter is, if you've been in the United States and you're out of status and you have overstayed, and chances are you're probably not going to be able to come back. So this, information that they're putting out there saying you should leave now so that you reserve your rights to be able to come back is actually not accurate. And so what we're saying is, before you leave, talk to an attorney to see if there's any pathway for you. Because if you have a pending application and you leave, that application is likely abandoned, right? So you want to make sure that there's no other pathway for you to get your status within the United States before you make that decision. It's just a good idea to know what your options are, because a lot of the information that's out there is really meant to scare you into leaving. And the reason is because the Trump administration cannot afford to deport people in 11 million people. So they're hoping to scare people into leaving on their own. All right. So let's talk about another matter um, which has come to our attention, which is the litigation with IRS, between IRS and, well, it's a litigation where there are people fighting there was a lawsuit seeking to stop IRS from sharing documents with the department, with DHS. So information sharing is ongoing, still going on, because the judge in that case declined to issue an injunction. But the case is not over, so we're not calling it a loss, or we're not saying that we haven't won that case. It's still ongoing, but the judge has just declined to put that injunction stopping the sharing for now. So the case is ongoing, and we'll see what happens as we go along. So I want to talk about Social Security cards. This is one that's going to probably affect quite a bit of people. In the past, when you applied for your work permit or you applied for naturalization, there's a box that you can check in to say that you automatically want your Social Security card, sent to you. So Social Security Office had this arrangement with immigration, where they would, send this Social Security card to you. But now that program was put on pause in March. And so what that means is that you have to go to the Social Security Office and apply for your Social Security card on your own. But the confusing thing is the forms still have that box that asks you to check it. So it's a little confusing now because the program has been paused, but the checkoff box is still there. So what we're telling people is, go ahead and check off that box just in case the program is restarted, because there's a lot of pushback. It's causing a lot of confusion, a lot of crowding in the Social Security offices, and so it's really not popular. So I also want to talk about the fact that there are going to be new forms for many of the form types that people are filing. So you want to look out for, I think the change will come around May 29, 2025. If you're putting in applications, you want to make sure that you're using the right form. If you're filing on your own, you want to make sure that you go to the USCIS website to make sure you're downloading the right form. So we also want to talk about Real ID. Went into effect May 7th, 2025. However, people are worried about that because they think they have to get a Real ID driver's license, which you should if you can. However, if you go to the website, it tells you all the other documents that you can use to travel if you don't have a Real ID card. One of those is a valid passport. All right. Now, what else? TPS. TPS ended for Afghanistan. That was announced in the Federal Register a couple of days ago. So the TPS is going to expire May 20th. The termination is effective July 14, 2025. So of course, that means that people from Afghanistan have to leave. However, before you leave, I always say, talk to an attorney and see if you have any other pathway, because you can have multiple pathways, right? Or if you file something that could give you a legal status, even if that you're not getting that legal status right now, if it puts you in a position of authorized stay, you may not need to leave. So that's information you want to talk to a lawyer before you leave the United States, okay? Right, what else? So another thing is, we've been seeing on the news what we call the weaponization of USCIS. USCIS is proudly putting on its social media how people have come from I-130, maybe a marriage case or interview with a family member, and they've been arrested and put in detention because they have an outstanding order of deportation. So it's important that if you have an order of deportation, you should talk to a lawyer before you go for those interviews, right? Because you need to know what's available to you. So if you don't know if you are in removal proceedings, there's a portal that you can, I think if you Google EOIR portal, it sends you to a place where you can put your A number in there, and it will tell you whether or not you're in removal proceedings. Now, how does it happen that you're in removal proceedings and you don't know? Well, typically, if you move, if you have an immigration process where it was denied and you were placed in removal, and you moved from where you lived, and they send that information to you, maybe a notice to appear, but you had moved so you didn't get the paperwork. That's how you find yourself deported in absentia, right? Especially if you had a court date and you didn't show up for the court date. USCIS EOIR will tell you that it's not an excuse that you didn't get the notification, because you're required to update your address within 10 days of moving to a new place, because government mail does not get forwarded. If it's not where you're supposed to be, it gets returned to them. It's not going to be forwarded even if you put a forward in your mail. So those are the important things that you need to know. So if you have an I-130, if you have an interview, you should check to make sure that you have no deportation proceedings, you haven't been ordered deported in absentia, and you didn't know about it. So it's really important for you to check that so that you can plan properly. And if you get an attorney, they may be able to advocate for you, okay? Now, let's talk about some good news. Well, the good news is, as much as we're getting a lot of this really, scary news about all the things that are happening to immigrants being in detention, I want you to know that I think there's a federal judge that granted a restraining order to a group of migrants that were being taken to Libya. They were being taken to Libya as a third country deportation venue, and the federal judge said no. And so the good news is, regardless of what's going out there, whatever the news you're hearing, there's been a lot of pushback from the legal community. There's a lot of lawyers filing lawsuits. The judges are pushing back on the overreach of this administration. The tough student that was arrested for, I guess, penning some op-ed has been released. There's been a lot of rulings by federal judges basically overturning some of this administration's decisions, or whatever, actions that they have put in place. So that's good news, because it means that the system is working. It's good news for the rule of law. So let's take some questions. I'm going to start with Kissy Girl. So Kissy Girl says, I'm planning for my fiance to join me in the United States. Can I go ahead? Well, Kissy Girl, you can file for your fiance to join the United States if, number one, you're a U.S. citizen, and number two, you have met up with your fiance in the past 2 years. There's a requirement, subject to very few exceptions, that you actually have to have seen the person face to face. And typically, I talk to clients about whether it's best to file an I-130 or whether it's best to file the I-129F, which is their fiancé visa. And it really depends. And I'll give you one of the times when you might want to, file a fiancé visa and not an I-130 marriage-based petition. If your fiancé has children under the age of 21, filing a fiancé visa can bring all of them here together at the same time under the same application. So your fiancé would come with a K1 and they would come with a K2 visa. That's not available when you file under a marriage-based case, because if you're filing under a marriage-based case, you're going to have to file for each and every family member. So that gets more expensive. Another thing is Another thing is that the fiancé visa is actually a little faster right now than the marriage-based visa, which is taking a little longer. So those are things that you might want to consider. However, if you file a fiancé visa, your fiancé will come into the United States. You have to get married within 90 days, and then they have to apply for the adjustment of status. They won't be able to work, and they won't be able to leave the United States without abandoning their petition. So if it's important for that person to be able to hit the ground running on day one, able to work, able to drive, able to do a lot of things, you might want to file a marriage-based petition so that they can do those things, as opposed to having to wait for the process to allow them to get their papers, to get the work permit and their travel permit. All right. You're welcome, Kissy girl. All right. So let's see. I'm going to see if I can get questions on TikTok, because typically I go to Facebook and Instagram because I can see those. Since I got my mini, since I got the mini iPad, I've been able to read the questions. That is so great. So BFit Seb says, I've been trying to get a consultation ASAP. Please, how can I go through that? BFit, please call the office at 973-993-1900 and ask to schedule a consultation. If it's a matter of something urgent, let them know it's urgent so that they can squeeze you in somewhere. If you go, you can also go through the website, but typically if you go through the website, it's going to take longer. Let's see. So Shazima Aziz says, how long does a supplement B form for U visa certificate take to be signed by NYPD? It really depends on the police departments. You know, some of them literally take 3 weeks. Some of them take a little longer. And, you know, it really depends. But I would say typically anywhere from a couple of weeks to 3 months. But it requires a lot of, sometimes it requires you to, you know, keep following up with them. But it really depends on the police department, okay? MB says, what about new citizens? Does the Social Security get updated when the box is checked? So MB, that's a really great question. So when you're a new citizen, typically you want to get a new Social Security card that doesn't have that language, not valid for employment and all that. Now that that program has been paused, you have to go to Social Security office and, you know, get your Social Security card updated. But like I said, if you're filing the N400 right now, go ahead and check that box, because the box is still there just in case the program gets restarted. So yes, new citizens, first time applicants that are just getting their Social Security number for the first time, all of you need to know that even though you check that box, you're still probably going to need to go to Social Security office to apply to get your Social Security card, okay? So Peace on Earth says 212 waiver approved for deportable crime before adjustment. Congratulations. And adjusted to LPR after waiver approved. Renew green card or N400 at this point. I am, what is this, allowable for N400, and CIMT is not an aggravated felony. Well, you know, Peace on Earth, you know, your questions like yours are more as specific to your situation. So I'm happy you got your waiver approved, and that's great, and you're able to adjust to LPR. But the N400, you know, there's a look back period. So look back within 5 years or within 3 years, depending on what the basis for your applying for the N400 is. And if it's not an aggravated felony and it's not a CIMT, I think you stand a good chance of being able to naturalize without a problem. But I don't know your case, and I don't know the details of your case. So I would recommend that you have a consultation with an attorney and just verify and just kind of make sure. A lot of times for this kind of cases, we actually make sure we get all the records. You know, we want to see everything from the criminal infraction, the police reports, if there was any pleas taken, how the case turned out. So even though you got all these waivers approved, which is great, and it's not a CIMT, it's not an aggravated felony, the N400 has a good moral character requirement. So we want to make sure that you can file and not have a problem with that good moral character requirement. Okay. Let's see. So Samuel Yearwood said, is this safe to travel on travel permit? Samuel, from time, we've always told our clients with travel permits that it is a risk. It's always a risk. It's always been a risk, because with a travel permit, if CBP finds you inadmissible for some reason, they don't have to let you in. That's always been the case. So I'm of the opinion that if you need to travel, you really should talk to an attorney so that they can ask you questions about, about your case. At this time, a lot of people are worried, and for good reason. So we're telling our clients, we've always told them that this is not a good time to travel, just especially if you're traveling on an advanced parole. Let's see what's going on with, this administration, let things kind of settle in a bit. But having said that, I'm going to tell you that many of my clients have traveled because people are going to do what they want to do, and they've come back just fine. Right? But everybody's case is different. So it's either you have a consultation with an attorney to discuss your case and kind of gauge your risk, or, do best practice travel, best practice travel behavior, which I'm going to say, be careful what you have on your social media. You want to remove all information there that gives them too much information about you, your life, whatever you want to, things you think that are private. But ultimately, it's up to you. I personally am not recommending people travel right now because there's just too much uncertainty out there. And but like I said, a lot of my clients have traveled. They call us, we talk about it, and then they go, and knock on wood, everyone has come back. All right. All right. So Peace on Earth says, can they come back and try to deport you as a CIMT, but a waiver was approved? So if a waiver is approved, Peace on Earth, it's approved, but I really think you should talk to an attorney, because I'm not giving legal advice without having more information, okay? I think you want to talk to an attorney before you file this N400, okay? All right, so let me go to Instagram. Instagram, how are you? Let's see if I can answer some questions for you guys. You're welcome, Peace. Lizzie says, thank you for updating us. You're welcome, Lizzie. Let's see. So Ogechi says, my cousin came with a working visa and is about to get married. What are her chances? Ogechi, your cousin's chances are the same chances that anybody else would have, If they're here with a working visa and they're married to a U.S. citizen, then it doesn't matter whether they're in status or out of status. And the only thing they need to show at this point is that it's a bona fide marriage, that they have no inadmissibilities, such as they want to make sure they came in with their own, identifying documents. They haven't been arrested, all of that stuff. Same chances. People are still getting married. People are still getting green cards. Don't let any of this stuff going on in the media fool you. People are still getting their green cards. The only thing is now we have to work harder to, to make sure that we are, there are no issues, And the thing is, to be quite frank with you, here at my firm, this administration is not really making that much of a difference, because we've always put everything in our applications, right? In our submissions, we've always been very careful. We've always had a 3-step, checking process to make sure we don't have any errors. So if you work with a law firm that has always been very diligent with making sure that their packages are properly filed, it doesn't matter who's president. Yes, sometimes they'll pick on things that shouldn't be picked on. They'll give RF fees just for the heck of it. Yes, that's what makes the process a little more cumbersome. But ultimately, people are still getting their green cards. People are still naturalizing. So tell your cousin that if it's a bona fide marriage and they have no criminal or inadmissibilities, they stand a good chance, and congratulations on them on their marriage. Let's see. So Latipo says, if you have a pending immigrant petition and the petitioner passes away before the applying, do you mean they pass away before it's approved? Because if they pass away before they apply, then there's nothing. So you're saying, what can the applicant do? Also, can you add another petitioner to an existing petition? So Ladipo, if you're here in the United States and there's already been an application, right, there's a way to, continue that petition even if the person passes, right? And in that case, another petitioner can be, if it's a family-based petition, you can have another petitioner, family member, standing to do the affidavit of support. Now, if the person is outside the United States and the I-130 has not been approved, there's really not much you can do. So if you have a problem with this, if this is your case or somebody you know, have them call our office. Let's see if we can assist them. We've done a lot of 204L humanitarian reinstatements, and we've been successful with those. So give us a call, 973-993-1900. All right. Keith Bethea said, what are your fees? Fees for what? Is it fees for the case or fees for consultation? Consultation fees is $200. And our fees for different case types depends on the case type. So everyone is forgiven says, I have an NTA coming up in July. You mean you have a court hearing? All right. I was denied because they claimed my marriage wasn't bona fide. So should I attend the hearing? Yes, you must always attend the hearing. You can never not attend the hearing, because if you don't, you will be ordered deported in absentia. And if you're ordered deported in absentia, trust me, it's really hard to reopen those kind of cases. So if you have a hearing, you must attend. So you're already in immigration court, get an attorney. And guess what? Even though you're in immigration court, it doesn't mean you're not going to get a green card. You just have a chance now to prove to the judge the strength of your case. And if you're able to prove that to the judge will grant your case, will give you a green card. There are many ways to get a green card in immigration court that's not even available before USCIS. So if you're in immigration proceedings, talk to a lawyer. We do a lot of work with people who are in immigration proceedings. Give us a call, 973-993-1900, okay? And everyone is forgiven, don't be afraid. Just get a lawyer and know what is going on with your case, all right? You say you got divorced. Getting a divorce is not the reason to say a marriage is not bona fide, okay? So you can always fight back, all right? Now, Nubian says, should I hire you as my attorney? Hi, I'm Deborah. Deborah, well, it depends on if we work on your case type. We typically do family-based, humanitarian, U visa, T visa, VAWA, SJIS, some asylum. We do removal. So if that is one of your case types, give us a call. Let's see if we can help you. 973-993-1900. Okay. Okinawa, 973-993-1900. That's our number. All right, let's see. I'm going to ask a couple of questions. I'm going to look at a couple of questions on TikTok again. All right. So Desert Lion says, where are you located? We're in New Jersey, but we serve clients in all 50 states because immigration is federal law. So If you have a problem, give us a call, 973-993-1900. I know I speak fast though. Ariana says, do you do 601 waivers? Definitely. We do waivers, 601, 601A. Waivers is one of our specialties. So yes, if you need a waiver, give us a call, 973-993-1900. So let's see. Believer Scrum says, you have a VAWA case for 42 months, no RFE and still pending. What should one do? So VAWA right now is taking about 36 months. And if it's 42 months, that means it's past processing times. You have an option to file a lawsuit. But typically, the best way to start is do an inquiry. Ask them what's going on. They don't respond, reach out to your congressman. And if your congressman is not able to help, call an attorney. Call our office, 973-993-1900. We will file what we call a writ of mandamus. We will sue the government. And people are afraid to sue because they think that if they sue the government, because their case is not moving, that they're going to get denied. No, that's not what it means. It means that they will have to make a decision, either to yes or no. The court tells them make a decision. So don't be afraid that it's going to lead to a denial. I'm going to tell you that we've done a lot of writ of mandamuses, and literally within a week, we have a response. And so far, knock on wood, it's all been positive. So if you're looking to move your case faster, that may be something you want to do, okay? Believer. So JP says, what are the chances of getting through documentation with a citizen who committed a felony? Now, that's a really good question, JP. If your spouse or parent or your American family member who's filing for you has a felony, that will not prevent you from getting your papers as long as it's not a crime under the Adam Walsh Act. So Google Adam Walsh, and that should let you know whether or not this person can get you your papers. Adam Walsh has to do with sexual crimes against minors, and I think, crimes against the elderly. But Adam Walsh cases are really, really hard to win. So if your family member, I'm assuming maybe a spouse, has he's been charged or found guilty of sexually abusing a minor, yeah, that's a no. That's gonna be a tough one. But if it's a felony, drugs, assaults, whatever, yeah, they could file for you. That wouldn't be a problem. So Nubian says she can't find her I-94. Nubian, there are two things you can do. You can do a CBP FOIA to see if you can find your I-94. You can go to the I-94 website, put your information in. You can file Form I-102 to see if you can get the information that shows that you came into the United States and you were inspected. All right. So TT Online Digital says, I want to know if I have to do the registration. I already have an application submitted since last year. Well, TT Online, like I said, what we're being told, because there's not a lot of clarity in this area, is that if you've submitted a case, you've gotten biometrics, you came in with a visa, typically you're likely already registered. So if you have any questions about that, talk to an attorney and see, and let them guide you through, okay? So Gonsalves says, how long does it take to receive a green card in a VAWA case after obtaining a work permit and travel document? Gonsalves, a work permit and travel document typically come within, I'd say, maybe a couple of months, maybe 2-3 months to 7 months, maybe, from when you file your VAWA case. But the VAWA case takes a long time. Right now, the processing times for VAWA is like 36 months. So go to the case processing website. Just Google USCIS case processing, and it'll take you there. Put in the information I-360, and it will tell you how long your VAWA case is likely to take. VAWA cases are taking a long time. All right. Let's see. How long is N400 taking? Funny enough, N400 is not taking a long time. That's a good news. A lot of the naturalization cases we filed in the past couple of months, we already have an interview. So go ahead and file if you qualify. I always tell people when they're going to file naturalization, you really actually want to have a consultation with an attorney to make sure that there will be no issues with your N400, because that N400 is USCIS's another chance to make sure that you got your green card properly. And if you didn't, they can place you in deportation proceedings. And if you're lucky, they would just deny the N400. But what this administration is telling us is any denial leads to deportation proceedings. Are they going to do that? We don't know, but because they're threatening so many things. What they can actually do, I don't know. But what we do know is they are serious about stopping immigration, whether legal or illegal. They're not just going after criminals, I can tell you that. So Karen Mohammed says, how long does it take after you file I-485 for F2A? Well, first of all, when you file the 485, I'm assuming that your priority date is current, Karen. And if it is, same amount of time, depending on what case type, who's filing for you, spouse, child. So yeah, as long as you're in legal status, because you have to be in legal status if you're F2A to file your I-485, and you also have to have your priority date current. Okay, Karen? Yeah. So as long as, the things I said to you, you're in legal status, your priority date is current, it's taking the same amount of time as it's taking for everyone else, okay? Which is typically about a year or so or less, It really depends on where you filed from. So those things are just, I think the best thing to do is to go to the case processing website and see how long it's taken, okay? And even that is an approximation. There's just no guarantees it's going to take you this amount of time. But I think overall, we're seeing around a year. All right. All right, let's see. Oh, wow. J-Lo says, I received a signed U visa certification, but the officer put that I was not helpful. I've never seen that before, J-Lo. Why would they even sign it if you were not helpful? So I think you would want to benefit from having a consultation with an attorney. 973-993-1900. Give us a call. We may be able to assist you. So Keith Bethea says, I'm currently married and want to bring my spouse to the United States. What is the process? I am new to this. So Keith, in a nutshell, if your spouse is abroad and you are a U.S. citizen or green card holder, if you're a U.S. citizen, then you have you're not waiting for a visa to become available, right? So that means the process will be a little faster. A little faster still means it's probably going to take about 1.5 to 2 years. So the first step is the I-130. You file it, you get that approved, and that basically says that you've established the relationship that you're seeking to establish, and then the case moves to NVC, National Visa Center. In National Visa Center, you have to fill out the DS-260, upload a bunch of documents, which include your spouse abroad has to upload police clearance. You have to upload your affidavit of support. You have to upload, what else? Affidavit of support, police clearance, DS-260, and whatever else is required. And once that's done, you submit it online, and then you wait for National Visa Center to let you know that your documents are good. If it's good and they accept it, they will send you information telling you that you're documentarily qualified. Now, if you're documentarily qualified, that's great. That could take about 4 months sometimes. And then at this point, you're waiting to get scheduled for your spouse is waiting to get scheduled for the interview at the consulate in their country. And depending on what country you're from, that could really take up to a few months to a year. So, yeah. All right, that's in a nutshell the process. If you need assistance with that, please call us. We're happy to help. 973-993-1900. All right, Munia says, can my daughter file for me? I have a deportation order because my I-485 was denied because of marriage fraud and a notice to appear in July 2025. So Munia, a 204C, which is marriage fraud, basically prevents you from getting a green card through a family-based petition. It's a permanent bar to a family-based petition. So if there was marriage fraud, your daughter likely cannot file for you. They're not going to approve it. And now you have a deportation order. And so you're not going to get a green card through your daughter. But there might be other pathways. A U visa maybe, a T visa maybe. So talk to an attorney. If you want us to assist you, give us a call. Let's, talk about your case. 973-993-1900. Let's see if there's something that can be done. But you say you have a notice to appear in July 2025, so you can't have a deportation order. So I think your questions are a little conflicting, but I think what you're saying is you're in removal court and your case was denied because of marriage fraud. So bottom line is marriage fraud prevents your daughter from filing for you. But you might be open, you might have a pathway through other means, okay? All right, let's see. Irene Maria Brooks says, what time is it? Okay, says, I filed for N400 on April 17th. You're a 10-year green card holder, married to an American citizen, clean case all around, awesome. My question is, how long should it take to get an interview? Biometrics through green card are going to be utilized. So Irene, I hope I'm pronouncing your name right. We are finding that we're getting interviews literally within a couple of months. N400 interviews are still moving quite fast. So that's really great. So I don't know exactly when they're going to call you for an interview, but the good news is they seem to be moving that case type faster. So chances are you're going to get called for an interview sooner than later, okay? All right. Okay, Allison says, USCIS denied my I-75 waiver and sent a reopen notice shortly. Based on the reopen notice, I got an I-551 stamp. What should I do next? Allison, you need to talk to an attorney because I need to get a lot of information that I'm not getting from this couple of sentences, okay? All right. Irene, you're welcome. So let's see. So Eddie says, how can one expedite military spouse applications? I think we did a couple one time. We did one for a spouse that had to go join, that needed to go join their partner at the base. And we did one for another person that had a cancer diagnosis. So it can happen. So if you need assistance, give us a call. It depends on the reason you want to expedite it. Call us 973-993-1900. So your K1 received a 221G. All right, yeah, we can assist you. Give us a call, 973-993-1900. Let's see what's going on with that, okay? All right. TT Online, you're welcome. All right. So official Muyirek says, a friend just got their green card in October 2024 through VAWA. When can she apply for citizenship? Well, congratulations. The good news, within 3 years. 3 years from getting the VAWA, your friend, I'm assuming is a woman or a man. Oh, it's her, yeah. She can apply for citizenship. That's excellent. Official, give her the good news. She doesn't have to wait for 5 years, okay? All right. All right, so let me see. I think that's all the questions I have, guys. And, I've been here for almost an hour, and I'll tell you the secret. The secret was I got the iPad, the mini iPad, and now I can see. Before, I couldn't read questions because the print was so tiny. I was using my phone. Anyway, so this has been a game changer for me, getting this mini iPad that allows me to read. Okay, so Munya says you received a 30-day deportation order in 2019, and then they sent you an NTA in 2020. So Munya, I'd like to see that. Give our office a call. Let's look into that for you. 973-993-1900. We do a lot of complex litigation. That's our specialty, complex litigation, hard cases. So thinking outside the box is our super strength. So if you have a difficult case, many lawyers have told you, no way, no how, no go. Give us a try. Let's see if we can assist you. I'm not promising you that those lawyers didn't know what they're doing, but sometimes, you need somebody else with a different mindset, which for us is looking and seeing how we can find a way within the bounds of the law, of course, within the boundaries of the law. And we've been really successful with cases that people have been told they could never get a green card, and we're able to find another pathway because we asked the right questions. We've gotten many people green cards through just thinking outside the box, because sometimes people don't ask them the right questions, so they don't give that answer that makes them eligible for a different pathway. Okay, so all right, so I think there's somebody that asked the question. Let me see. Just says, I won the DV last year and it's 4 months closer to ending, but I haven't gotten my appointment date yet. Do I have a chance of being approved? And I have a bit of documentation problem with education. So I don't know what that is, but I don't know. So I think you should, I don't know. Yeah, I think you should reach out to them and see, what can be done, but I really don't have an answer for that. So Zach Gando says, can USCIS think a 15-year marriage is not bona fide if couple are not living together because of work? A lot of people, I've said this before, that USCIS likes people living together. They like traditional marriages. However, we've won many cases where the couple do not live together. So it's not so much whether or not you live together. It's why don't you live together? Can you explain why you don't live together? And if you can explain credibly why you don't live together, and you have other bona fides, you stand a good chance of getting your green card approved. So just because you're married for 15 years is not going to be the reason, because some people get married, they forget, they don't divorce themselves, but they're not living together. That's not evidence of a bona fide marriage. You really need to show them a slice of your life. So for instance, you don't live together, but you're visiting each other. You have proof that you're flying to your spouse's place. You have proof that you're taking vacation together with your spouse. You have proof you have children together. So if you don't live together, that will not be a reason that your case is denied. All right. And as a matter of fact, when my husband and I got married, we didn't live together for like a couple of years because he was working in another state. I was in New Jersey, and that didn't matter. We're still married, so 3 kids. All right. So I hope that gave you some consolation. If you need any assistance, feel free to call us, 973-993-1900. We're always eager to assist our fellow immigrants. And it's been a pleasure chatting with you guys. And I will see you again next week. Take care.